Ladies and gentlemen of the jury, the prosecutor has just told you what they claim they will prove in this case. So I will now tell you what those of us representing Mr. Donahue will prove in this case. And I would say this 1,000 times over if time allowed. Those of us representing Mr. Donahue will prove absolutely nothing. And we will prove absolutely nothing because in a criminal case like the one you are a part of, there is nothing that the defendant can prove. The only question you will have to decide in this case, once you have received all of the evidence, is whether the prosecutors have proved any of those 10 crimes they have alleged beyond a reasonable doubt. There will be no questions for you to answer as to what, if anything, Mr. Donahue has shown in this case. The only question is whether the prosecutors have proved anything beyond a reasonable doubt. So that is why we will be proving absolutely nothing. That does not mean we will not have questions for the prosecutor's witnesses and several questions for some of their witnesses. But all of those questions are not intended in any way to prove anything. Our only purpose in asking those questions is to determine where the prosecutor's evidence fits into the reasonable doubt calculation you will have to make at the end of the case. In proof beyond a reasonable doubt, which was discussed a lot during jury selection, in which the judge has preliminarily instructed you on, that is the only evidence by which you should judge the prosecutor's evidence by as you are seeing and hearing it. And in this specific case, proof beyond a reasonable doubt would mean that as you are hearing and seeing the evidence, you are thinking that there is only two things all of the evidence you are hearing and seeing could reasonably show. The first is that you're hearing and seeing the evidence. The only reasonably possible explanation is that Mr. Donahue was the person in the cases, as the prosecutors have alleged. And secondly, that the only reasonably possible explanation from all of the evidence is that Mr. Donahue committed every single item on the so-called checklist of every given crime that the prosecutors have alleged. So as you are hearing and seeing the evidence, there might be a point where you conclude that one reasonably possible explanation of all of that evidence is that Mr. Donahue was the person in the cases and committed all of the alleged crimes. But again, if there are other reasonably possible explanations from the evidence that would allow you to conclude to the contrary, then you would be having reasonable doubts as you are seeing all the evidence that will be presented to you. So stated similarly, the evidence that you will hear and receive has to establish not only that one reasonably possible explanation is that all that is true, it would have to establish that the only reasonably possible explanation is that all of those allegations are true. So there are two questions that I ask that you be thinking to yourselves as you are hearing and seeing all of the evidence in this case. The first question I ask you to consider: does any given piece of evidence you are hearing or seeing help the prosecutors rule out the possibility that someone other than Mr. Donahue might have been the person in the cases? If the answer is no, that particular piece of evidence would be giving you a reasonable doubt. The second question I ask you to be thinking to yourselves as you hear and see all of the evidence is, does that particular piece of evidence help rule out the possibility that Mr. Donahue did not commit any given checklist item on all of the crimes that the prosecutors have alleged? If your answer to that question, as you are seeing any particular piece of evidence, is no, that piece of evidence would be giving you a reasonable doubt. Some of the evidence you will receive will be from the 4 eyewitnesses that the prosecutor has mentioned. Mr. Jacob Christensen, a Casey's employee, Miss Madeline Stepanek, a second Casey's employee, Deputy William Halverson, and Deputy Heath Omar. There will be no dispute at all that what those 4 witnesses experienced was very traumatic and very scary and any number of other terrible things. There will be no dispute about that. And regarding Deputy Halverson, there will be no dispute at all that what he experienced physically was extremely painful. And the questions we will be asking of those 4 eyewitnesses are in no way meant to demean or diminish anything that they experienced. Our questions will be in no way intended as personal attacks on them. Our only purpose in asking them questions and asking all the other witnesses questions is to determine where their stories fit into the reasonable doubt calculation. During the testimony of those 4 eyewitnesses I mentioned, I expect all of them from the witness stand to point at Mr. Donahue and say, that's the person I saw in the Casey's, or that's the person that shot me, or that's the person that I was chasing in my patrol car as I was responding to the scene. And the first impression you may have of that evidence is that it is very strong in the prosecutor's favor. But when we have a chance in this case to present witnesses, one of the witnesses we will present is a gentleman named James Lampinen, and he is a psychology professor at the University of Arkansas, and he has been since the 1990s. He has a PhD degree in psychology from Northwestern University, the school in Chicago, not the one in Northwestern Iowa. And in his writing, research, and teaching, he specializes in studying eyewitnesses to crimes and the factors that make their identifications of the perpetrator more reliable or less reliable. He will tell you about those factors, and he will tell you about all of the scientific studies that confirm those factors. 6 of the factors he will discuss, I will briefly mention right now. And all of these factors contribute in a substantial way to the unreliability of any eyewitness identifications of an alleged perpetrator. The first factor is whether the perpetrator was wearing a hood or other sort of head covering. That's a factor that has a substantial effect on the unreliability of any identifications. The second factor is that the perpetrator is of a different race than the eyewitness. And that is an especially important factor when the eyewitness does not have much experience being around a person of the same race as the perpetrator. The third factor is whether the eyewitness was in a high-stress situation at the time he or she observed the perpetrator. The fourth factor is the length of time that the eyewitness saw the perpetrator, commonly referred to as the exposure time. The shorter the exposure time, the more unreliable any eyewitness identification is. For the 4 eyewitnesses, I expect the exposure time to be as short as 2 seconds and only as long as a handful of minutes. The fifth factor is whether the eyewitness, prior to making any identification attempts, has seen pictures of the person who prosecutors have accused of the crime, and when seeing those pictures, the pictures label the person as the one accused. And the sixth factor I will mention at this time is whether the identification attempt itself happens under circumstances that make it obvious to the eyewitness who the person is that the prosecutors have accused of the crime. One of those inherently suggestive circumstances is when the identification attempt is made at a trial where it is obvious to everyone in the courtroom who the person is that the prosecutors have accused of the crime. So when those 4 eyewitnesses testify, we will be asking them questions that are relevant for those 6 factors I just mentioned. Therefore, please reserve any judgment you may have on the reliability of those in-court identifications the eyewitnesses will make until you have heard Dr. Lampinen's testimony. I expect that to be next Thursday in the afternoon. And until you've had a full and fair opportunity to discuss during your deliberations that identification testimony. And please remember that the identity of the person in the cases is only part of what the prosecutors must prove beyond a reasonable doubt before you can return the guilty verdicts they have already committed to asking you for. Because in addition to the identity of the person in the cases, the prosecutor, as has been mentioned, must also prove those checklist items for each and every crime that they have alleged. And I will now briefly mention some of the important testimony I expect that will be relevant to some of those checklist items. For the attempted murder charge, the relevant testimony and time periods will be the handful of seconds leading up to the encounter between Deputy Halverson and the person in the cases, and how the person in the cases acted or did not act towards Deputy Halverson afterward. The interactions between the perpetrator, the person in the cases, and Mr. Christensen and Ms. Stepanek will be very relevant to the checklist items for the robbery charges. Same for the other 7 charges. At this point, I won't bother going through all 7. But again, please keep in mind that the identity is only part of the case. An equally important part of the case that the prosecutors must prove beyond a reasonable doubt are all of those checklist items. So in addition to the identity issue, please keep in mind those reasonable doubt questions I suggested that you consider on those checklist items. And I will conclude my statement, or my opening statement, with a statement on the presumption of innocence. The judge has preliminarily instructed you on that, and it was discussed extensively by both sides during jury selection. Everyone acknowledged it was very important, yet before presenting any evidence and before anyone can be certain what the evidence will turn out to be in this case, the prosecutors have committed already to asking you to return guilty verdicts at the end of the case. That is a request that disregards the presumption of innocence, and please do not do the same thing yourselves to one of the fundamental and foundational legal principles of American law and free societies everywhere. Your Honor, I conclude my opening statement.
Thank you.